Doshok, dear viewers, welcome to my live show on Facebook and YouTube as well. Whoever watching from my program, this is a live show. If you have any question, you can feel free to leave a comment. Today, I'll speak about very important issues. First, that is the issue is about a lot of EU family member. A lot of EU family member are getting EU family permit, but Home Office is not allow them to travel to the UK. I will ask you what are the issues, why Home Office is not allowing you to travel to the UK, and what are the steps you should take now to get a way to the UK. The second issue, the topics I'll discuss today, the outcome of the debate regarding amnesty in Parliament, that where the government is going to give amnesty for those overstay in the UK. As you know, last week there is a debate in Parliament, in the House of Commons, regarding whether the government should give amnesty for overstay or not. So let me speak about first EU law. I will also give some update about the Zimrano, who are familiar with this. So let me speak about first the issue regarding EU family permit. Now, a lot of people made application under the EU law to get a family permits after Brexit or before Brexit. Some people get their family permit. Some people made the application quite long before in 2019 or 2020 or 2018. However, the Home Office refused their application and subsequently they appeal and they get they win the appeal. The court ordered the Home Office to issue a family permit. Home Office issued family permit. However, by this family permit, by this EU family permit, they are unable to travel to the UK. Some people applied for EU family permit in the last minute under the EU law. However, unfortunately, they are unable to travel to the UK because of the change the law from EU to EU settlement scheme. And unfortunately, again, Home Office not allow them to travel to the UK. Other group of people, even the Home Office even didn't issue family permit, rather than they write a letter that there is the Home of EU family permit is no more valid, and accordingly we cannot issue family permit because of this reason. Now, what you can do? Now, first things first, those who made an application in the last minute under the EU law for EU family permit, my observation is this application was a wrong application you have submitted. You have submitted a wrong application under the correct law. This doesn't make sense from many of you maybe, but you need to understand that because of the Brexit 2019, when Prime Minister Theresa May gave notice to the EU authority that we are going to leave the UK, the referendum notice, after that the government introduced a settlement scheme. So that time, and that they agreed with the EU that the EU law will continue until the transitional period, and that is at the 30 December 2020. And after that, there will be no more EU law. So as there is no EU law, that means you cannot exercise the right under the EU law as well. However, some people mistakenly or the lack of understanding, they make the application under the EU law rather than under the EU settlement scheme. Now, that is clear that you made the application under the correct law, but in wrong time, because as you know, EU law will be not applicable after Brexit, after the transitional period. So if you get a family permit, you cannot exercise this right under EU law or EU family permit, whatever you are given. Now, some other issue where the Home Office is wrongly refuse your application, you did an appeal and you win the appeal, and the time you get the family permit, that time it already over, and you cannot travel by this the family permit. So in these types of case where the Home Office in default and undissolvably, unlawfully refuse your family permit, subsequently you win the appeal and you get the family permit, for these people have a right to travel to the UK. However, there is a no law because EU law has changed. So what you can do now, if you are in a situation where you win the appeal, you got the family permit, however, or you win the appeal but Home Office refused to issue family permit. If you are in this situation, then you can ask the Home Office that it is not my fault, it is your fault because Home Office refused your family permit unlawfully. Home Office refused the family permit unreasonably, which was established by the decision of the first tier tribunal or upper tribunal. Accordingly, Home Office should take this responsibility and issue them appropriate travel permit, either under EU law or under EU settlement scheme, or should give them a concession and allow the EU family member who got family permit under EU law to travel to the UK. If that letter not work, you should go through a judicial challenge. That is, you first issue a pre-action protocol to the Home Office because you cannot do appeal because already appeal is shorted. Because this is unreasonable, Home Office, not to allow these people, these EU family permit holder, to travel to the UK. You should issue a pre-action protocol letter to the Home Office, that is the government legal department, that if you do not allow them to travel or issue an alternative appropriate visa, then we will go to the judicial level. So you should first issue an appropriate pre-action protocol, and then you should go proceed to the challenge, because this is a lot of thousands of people who got EU family permit, but they cannot travel to the UK because of the restriction, because of the red list country, because of some other reason, because of there is no more EU law. But these people have right to travel. Home Office unlawfully restrict their freedom of movement. Therefore, Home Office should take this responsibility and allow them an alternative travel route, which is reasonable, to allow them to come to the UK. So that's what you should do. I think if you are in this situation, it's not might appropriate to take any action by yourself. It is better to speak with a lawyer, experienced lawyer, who know all this sort of EU law and the latest outcome, what is judicial review, and then you should go ahead. You shouldn't just give up this matter because you have right. So this is what about update for EU family law, EU family permit. Now let's move on. The next topics is I'll give briefly about the debate about amnesty, whether the government should give amnesty for overstay people or not. There is a debate in Parliament. Unfortunately, there is no positive outcome. As usual, the government raised their concern, gave their position that the government doesn't want to give amnesty for the overstay. However, what the government minister said, that there is already the law is in place regarding those people who came in the UK for a genuine asylum seeker. Those people who are in the UK who will face significant obstacle on return of their home country, such as if any person, whether irrespective of their duration in the UK, if they establish that they will face significant obstacle on return of their home country, they can claim on the basis of human rights. The other group, those who are refugee under the definition of Article 1 of UN Convention on Refugee 1951, they can claim asylum as usual, but the government don't want to give an opportunity for smuggler, criminal, those people who want those smuggling people in the UK. That's what the government doesn't want to give an opportunity. So that was the conservative government position, which was before, and the last debate, after the debate, they also cleared their position. Unfortunately, many people in the UK who genuine asylum seeker, who are overstayed, who are living in the UK quite long time, but because of the right advice on time, because of the right application, these people fail to establish their case. Now their position are overstayed, they are not getting help from government, from any local authority, or from any home office. So these people are living in the UK quite long time. These people, everyone made the petition, support the petition. More than 104,000 people signed this petition, and that was subject matter of debate in Parliament. However, we didn't see any hope that the Conservative government will going to give amnesty. Although the Boris Johnson, the Prime Minister, when he was Mayor of Parliament, he was on side of amnesty for those people who were in the UK for quite a long time. And we had a hope, every professional human rights worker or the was that when Boris Johnson became a Prime Minister, when he entered in number 10, that he will introduce some sort of amnesty in the UK so that the Obostar people can get a paper in a document or their visa or leave to remain in the UK. Unfortunately, the current government is more strict. What they introduce, the UK border bill, the Home Minister Priti Patel, that is UK border bill, the second reading has already done in the Parliament. More probably, there are more chance that this border bill will be passed as a law within a couple of weeks or couple of days. Once the UK border bill will be will be law, from that time those who enter UK illegally, means they are in their language, such as by dinghy or by a lorry without any visa, the law will consider these people are criminals, which is very unfortunate. We don't support it. Every people who travel to the UK, they are prosecuted on their country, most of them, or they are prosecuted by the middlemen. And the thing is, the people who travel from, for example, Turkey to Syria, or Syria to in Europe, or anywhere by Europe, these people left French or Italy, Spain, because they feel insecure. Because in my position, my opinion, that the people who travel, for example, they have the people who smuggling people in Europe, and they give threat that we need to leave this country to travel, so they escape from there as well to look a safe country. Now, government position is they don't understand the main issue. They think that smuggling people and who enter in the UK illegal way is a crime. Unfortunately, right now, whoever entered by dinghy or by other way, the Home Office give them protection. They take them in accommodation, hotel, provide them support. But in future, once the UK border bill will be a law, that time, rather than taking the asylum seeker in a hotel or accommodation, they will take you in prison or police station to charge against you, and next day they will take you in the magistrate court or crown court to charge against you. That's what going to be future of asylum seeker, unfortunately. Let's see where it go, but of course it will be subject to challenge, a lot of judicial review or court of appeal about the UK border bill. I hope the Home Secretary and the parliamentarian member of the parliament will do necessary amendment so that the UK border bill will be fair for both asylum seeker and for this country as well. Thank you very much, all of you who are watching. Now, let me talk about the other issue, which is about the EU law. I already it is important, not EU law. I'll give the Zambrano application. Zambrano application deadline is going to end 12th of August. So basically, it was 6 weeks from the 1st July. So if you are a carer of a British child or of a British citizen, please make the application as soon as possible within this week, because the deadline will expire. Unfortunately, will not able to make this application. Then again, the EU settlement scheme, many people miss the deadline to make the application. Now the question is whether you can make still application. Yes, you can make still application if you establish a reasonable excuse that because of that reason you cannot make the application, you couldn't make the application on time, that still you have chance to make the application on a EU settlement scheme as to get a settle or pre-settle status. The other thing what I want to also address is EU family permit. Many people is confused whether they still can bring their family member from Bangladesh, India, Pakistan, Africa, Ghana, Nigeria, anywhere in the world. Yes, you still can bring your family member to the UK under EU settlement scheme. Same requirement as it was before. Only the excluded group is the extended family member. Extended family member cannot come to the UK unless they had established a relationship and hold a certain document which was issued before 20 December 2020. Now only family member, close family member, they still can come to the UK under EU law by applying for EU family permit under EU settlement scheme. Viewers, the next thing I want to give you about the okay, about the EU settlement scheme, the long residence is very important for many people. There is a case law came from the UK basically from upper tribunal regarding long residence, Wasim and other versus Secretary of State, Home Department. This is the interpretation of long residence. As you know, the last year same case came. The Khan case came last 2 years. Couple of cases come regarding long residence, that is 10 years rules. Many people are confused that if you are in the UK and if you spend 10 years, then in addition to add the 14 days time, which is you can make an application after 14 days, and then you can get ILR in the UK. This is not in this is not the case actually. So 10 years, what the court said is long resident. 10 years mean 10 years. You cannot take advantage of 14 days to complete the 10 years. So there is a two 14 days old. One is open-ended and another one closed-ended. That is what you need to understand. So basically, if you want to make an indefinite leave to remain application on the basis of 10 years rules, then you can make the application when you will able to make the application at the point you completed 10 years, right? Now, if your visa is expired today, but it's not 10 years yet, maybe 1 week still, you need 5 days or 6 days, then some people, what they do, they think that as I can make the application after 14 days, so wait another 5 days or another 7 days, complete 10 years, and then I'll make the application and I'll tell the Home Office that my 10 years completed and please issue me indefinite leave to remain. The Home Office set the rules and the court said that the 5 days what you was in the UK after your visa expire, basically you was an overstay. So that 5 days which you made a late application made you an overstay, and your 10 years continuous residence is a break. So therefore you will not able to make an application that under the 10 years rule. So it is very important to understand that 10 years means 10 years. You cannot add another 14 days to complete 10 years. However, if you previously overstay, means 14-day overstay or less than 14 days, this is what is called close-ended 10 days. So that will not be an issue. You will not be overstayed. But the last 14 days, if you overstay, then you are overstayed. Now, the next thing is I want to give you then, it's not a good news about the 7 years rules. Again, also important, a case came from the Court of Appeal under the 7 years rules in NA Bangladesh, Secretary of State for Home Department. The many people think that if my child is in the UK, and this is the human rights rules, that if a child who is under 18 years old spends 7 years in the UK, and if a 7 years rule applied, then you can apply for leave to remain under 7 years rules and you will get visa leave to remain. This is not an absolute rule, because this is a discretionary rule. This is a discretionary authority of the caseworker or home secretary or her representative whether they issued the leave to remain visa for the child or not. How it become discretionary? Because when someone make an application under 7 years rule for the child, the question is before the caseworker is whether it is reasonable to expect a UK born child to leave UK, whether it's a reasonable test. Now, NA Bangladesh and Secretary of State for Home Department 2021, in this case, Court of Appeal said the question was before the judge was whether it is reasonable to expect a UK born 11 years old to move Bangladesh. The Court of Appeal said, what the Court of Appeal said is, yes, it is reasonable because the parents have no visa, they don't have leave to remain, and the parents will be required to leave a UK to go Bangladesh, and accordingly the child should go with their father, with their mother. Therefore, it is reasonable for the child to leave UK. So 7 years rule solely it very difficult by the following this decision. So if you are required to make an application under 7 years rules, before make the application, please speak to a lawyer, because if you just solely depend on the 7 years rule, your application might be refused by the Home Office on the ground that it is reasonable. This is the most approach of the Home Office, and it was validated by the court decision of Bangladesh. So this is, of course, is not a good news. Dear viewers, I'll take the question. A lot of people ask a question regarding their inquiry. Let me check what are the question is, and then if you have a question, please leave a comment. I'll give you an answer. So Nantona Kuti, any news on Jamrana Court of Appeal? Jamrana Court of Appeal decision still is pending, and we don't have any update. Please subscribe my channel, and once the decision come, or once the date of hearing will be fixed, I will let you know. And the hearing of Jamrana case will be live in my YouTube channel and Facebook. So if you're watching my program, please subscribe it, because I will do live that day, and the court hearing is available to public, and it will be live from my Facebook and YouTube channel. So please bear with me and stay subscribed me. You will get the decision soon. But make the application. Don't wait for the Court of Appeal decision. Make the application now. Don't wait, because you don't have much time left. You have only a couple of days. Then after that you will not able to make the application. So make the application and wait for the decision, because it will not cost you anything. Is a free of application. There is no Home Office fee, no NHS fee. Just submit the application with supporting document, and if you are lucky, I believe, is my opinion, that Court of Appeal will uphold the High Court decision, and thousands of mother of British child, thousands of father of British child, thousands of people who providing care for a British child, they will able to get pre-settled or settled status under EU settlement scheme, under EU law, rather than waiting 10 years long way to get ILR in the UK. Lots of money, lots of fee you need to pay to the Home Office, to the solicitor. All this money you will save. You will get, some people will get straight to ILR. Those who are parents of a British child or carer of a British citizen who already spent 5 years in the UK, they will straight away get ILR if the Court of Appeal not overturn the High Court decision. So please make the application. Next question is, sir, how much time after biometric residence card? I don't understand. What do you mean? So please clear your question. I'll give you answer. Alison, how long it taking Home Office to reply fresh appeal right to stay, please? Currently, it take 6 to 8 months, so it's quite long time. But it depends your immigration other issue involved, for how many times you make the fresh application, whether it's a further submission or a fresh asylum. So this depend on this. Then next, when debate again, sir? I don't know again when will be debate about the overstay, but hopefully again maybe someone start a petition, and if it is over 100,000 people sign the petition, then will be another debate. Next, just missed the current update on the Zambrano case. Has the Home Office appealed yet? Home Office has already appealed, and it is pending before the Court of Appeal. And the next case, Tesaranga, what can support my case if I'm looking for a 7-year for my child? What can impair my case? Okay, this is a very good question as well, I think. So if you want to make an application on the basis of 7 years for the child, so there is two things. First, you can either only make the application on the basis of your child, or you can so the child will apply. Okay, first child will apply, and then the parents will apply after that on the basis of child. Okay, this is the one option. Other option is now your answer is what other stuff you can add that which will increase the weight of your application. So 7 years rules. Now if you just tell the Home Office that my child is 7 years old, therefore give him leave to remain, they might refuse their application, because they will say it's not reasonable. It is reasonable for a child to live with the parent, because parents have no leave to remain. So what other thing you can add more stuff, such as you can provide more strong evidence that the child is strongly bound with the UK, the child has strong connection, the child has strong tie with the UK. So you can provide evidence from school, letter from school, letter from friends, group friends, from picture from the friends. The child go to any club, any sporting club, any playgrounds connected with the community. To all these things relating to child, you need to provide. Okay, letter from school, friends, picture, all these things. Number one. Second things, as you will be also adding the 7 years rule application. So what you have a strong bond, you have strong tie. If you volunteer in any community, if you go to churches, if you volunteer, if you want a church, letter from church, letter from community club, letter from the relatives, that was, and your legal argument, how you connected, why you need to live in the UK, what the human rights involved, which article involved, Article 8, Article 2, this is what you have connection with the UK. So that will weight your case. Okay, that then what say this, not only child interest or child legal basis they need to consider, they need to consider your situation as well. Another thing you can also can add, you can make an argument that if you require to go in, for example, Sri Lanka, what will be the problem, what issue you'll face, how you might be prosecuted, whether your human rights will be breached, whether you could consider as a refugee. So what problem, what issue you will face on return of your home back home. So these are the stuff you can add, then it will increase your chances to get a visa on the basis of 7 years old. What I could advise you or request to invite you, if you want to make an application on the basis of 7 years rule, speak to a professional. This will be very helpful. Thank you for your question. Next question. How long for a decision from a Home Office for application under Appendix FM as a parent of a British child? Normally 6 months, less than 6 months, but currently they are taking a bit delay. But if it is cross the 6 months, you should speak to you can speak to you can write a letter, send them an email, or you can, last resource I advise that you can speak to your local MP. The MP will write a letter to get you an update. But Stephen, you can think about the Zambrano carer application, because if you are parents of a British child, you can make an application for Zambrano, which a lot of advantage. I have some separate video what I uploaded, please watch this. You can make an application under EU law if you are a parents or carer of a British child. I'll not discuss it again, but please, I have a lots of video about it, you can watch it or speak to a lawyer. Then having the right to appeal, it is good news for asylum. Of course, if you have right to appeal, this is a good news. Normally the Home Office have a right, they couldn't, if they want, they could say, well, you have right of appeal after you leave the UK. So out country right of appeal. in-country right of appeal is good for you. So I don't know whether you get in-country right of appeal or out-country right of appeal. If you get an in-country right of appeal, this is good for you. You can appeal to the court, and in the court you can explain your situation. If your circumstances has changed again, you can make a further submission. You can provide more evidence to the to the court, because in the home office you had no opportunity to tell the caseworker directly, but in the court, tribunal judge is the decision maker, and you can tell the judge, because you will appear to the court and you will give evidence, and you can tell the judge, this is my situation, I'll be prosecuted if I require to go my home country. Because I'll not pick up the phone. If you have any if you need help, please later tomorrow call my office, and someone will give you an appointment. Another petition started on Parliament side. Go and sign. Brilliant. If you watching program, please sign it. I'll do as well. Asylum seeker 7 years here have heard about any news. Unfortunately, I don't have any news. So still, I said that if you can establish that you will face a significant obstacle, you can make the application. Then next, 11 years staying in England, British passport holder, please tell me. Your case doesn't, your question doesn't clear to me. If you can give the full question, I'll give the answer. Thank you so much, Tessa. Thank you very much. I appreciate. Then, can graduate from Africa apply for work permit? Yes, you can apply for work permit from anywhere, but there is a certain requirement. If you can fulfill, there is a 70 point you need to achieve if you want to get a work permit visa. So please, I have a separate video. You can watch my video, and then you'll get some information about it. Can get married with English citizen if I am illegal immigrant. My girlfriend about 7 years. I'm not sure what you mean, but I think if you have a girlfriend 7 years, then you can apply for on the basis of unmarried partner visa if you live with her for 2 years. So even though you are not married, but if you can show the home office that you are living with her for two years or more than 2 years, then you can apply as a unmarried partner visa. One option. Other option, you can make an application on the basis of human rights again. If you can show the government that you will be required to go, if you require to go back to your home country, you or your girlfriend will face significant obstacle, the obstacle which cannot overcome. So maybe your girlfriend will not able to speak your language, so this is a significant obstacle. You can make an argument, so you have a good argument against the home office. Try it, speak to a lawyer, speak to a solicitor. If there are a lot of guidelines regarding in your situation, I think you have you should speak to a lawyer. Maybe you will be able to get something good advice. Viewers, thank you very much, all of you who watch my program. And if you need any help, please speak to me or please give a ring to my office, and any information we can provide you if you need anything, any help. And all of you. And if you need any appointment, this is our office details. You can call to this number and make an appointment. We are available from tomorrow. Thank you very much. I will continue to give update. Please subscribe my channel if you so we will get update all the time, because every time when any case law come, when any home office change any rule, I gave them update on this on my channel. So please give a call tomorrow, and if you need to make any appointment. Thank you very much. Take care, everyone. Be good with your family, with yourself. Look after yourself, and pray for me. Pray from the whole people who are trying to be good, trying to be do something for our community, for our brother and sister, everyone. Thank you very much.